For more on Saturday's proceeding and the wider case, we go to Arun Rath, who has been reporting military justice stories for our PBS partner Frontline, and Josh Meyer, co-author of the new book, The Hunt for KSM. He now teaches and directs a program at Medill Journalism School's National Security Initiative. Both attended the session at Guantanamo. So, gentlemen, starting with you, Arun, take us inside that room. What was it like for this marathon session?
Well, the gallery room, which is where the journalists who were in the pool selected to go in, as well as the 9/11 family members and some representatives from NGOs, it's part of the courtroom, but it's separated by double-paned, supposedly soundproof glass for security reasons, and also so that what we hear the court loudspeaker played, but on a 40-second delay. Sort of like, what a shock jock would use, so obscenities don't get out in the air. This is so that they can stop, the proceedings, and people won't hear if something comes up for security reasons.
And Josh Meyer, it sounded, from reading the accounts, it sounded as if KSM, Khalid Sheik Mohammed, was very much in the lead among the defendants in sort of his behavior.
Yeah, I mean, he stayed true to form. He's the leader of the group, and he's a very disruptive presence in the courtroom. But what's different about this from the last time I was there in 2008 and the last time we saw him publicly is in that case he was very defiant, very loud, had a lot of outbursts. And in this case, he basically was showing his opposition by not saying anything, not doing anything, and telling the others to do the same.
And then what, some of them took out prayer rugs and started praying?
Yeah, one of them, Walid bin Atash, removed his shirt in the middle of the proceedings to show his alleged scars from torture. The judge obviously told him to knock that off. Another one stood up to pray at an unscheduled time in the middle of proceedings. And then there was Ramzi bin al-Shib, who shouted out in the middle of the proceedings, saying that he was worried that they were going to kill him and make it look like a suicide, that he wouldn't be back again.
And the defense attorneys raised a lot of objections, too.
Yeah, I mean, it's pretty clear from their objections that this is going to go on for forever. One of the attorneys told me that it could be years, maybe 4 years before there's a trial. But what they were doing and what they said that their clients were doing was just protesting, a silent protest for what they said was the unfairness of the whole system from front to back.
As we saw that defense attorney Connell say. But to what end? I mean, is this to lay the groundwork for future appeal?
I think there was a lot of that. I mean, during the
because they can appeal to federal court, right?
Right. There was a lot of questioning of the judge, bringing up issues. One attorney basically questioned his qualifications. The other questioned his objectivity. There were, I think, a lot of laying the groundwork for appeals in the future.
Now, the torture issue, how is it, I mean, some of the objections, again, as we heard from Connell, had to do with trying to introduce the idea that their clients had been tortured or mistreated.
Right.
What is will they be allowed to testify about that? What does the defense want to do with that in terms of strategy?
Well, that's one of the big questions is so much of this process is top secret and classified that we don't even know whether they're going to be allowed to do that. The lawyers for the 5 men say that they're not even allowed to discuss this with their clients, their time in captivity, what the CIA did to them, whether they're going to be able to introduce that in court. So, of course, that's extremely important. Whether they can, there's an assumption that they're going to get convicted, but, whether they get the death penalty, the torture issue, I think, will be extremely important in terms of a mitigating factor.
And as we heard, they're not going to be using evidence in court that was derived from the harsh interrogation techniques. But the defense is contending that, these guys were tortured right from the get-go, and anything that's come out of their mouths since then, even though it was obtained by supposedly what they call the clean team, who went in and obtained interviews without using these techniques, it's still tainted by the torture, and they're going to try to have it thrown out for that reason.
Now, remind us about Khalid Sheik Mohammed and the role he played. You've just written a book about the hunt for him, the role he played in al-Qaeda in the years when it was most effectively operational.
Well, it's interesting, and that's a good question. There's a big disconnect there. I think most of the American public think that Osama bin Laden is the guy who did 9/11. And when you really look at it, Khalid Sheik Mohammed he was the guy who brought the plot to bin Laden in '96, had to spend 2 years talking him into it. Finally, he got the green light to do it, and he got a little bit of manpower and some money from bin Laden, but he did it himself pretty much as an independent contractor. He kept his independence from al-Qaeda so he could run it his way. And during that whole time, he was also plotting as many as a few dozen other attacks. After 9/11, he personally decapitated Daniel Pearl, the Wall Street Journal reporter. So you know, when people think of bin Laden, he actually was the guy sitting up in a corporate office, you know, not doing much in terms of actual operational stuff. KSM is the guy that was out there traveling around the world and getting things done.
Now, about 4 years ago, I think at a hearing, Khalid Sheik Mohammed proclaimed that he was behind 9/11. Does the way their attorneys acted suggest now they have a different strategy?
Well,
I mean, in other words, he's sometimes described as the confessed or self-professed mastermind.
Well, I think what they would say again is that that statement was made even though in that same thing that's where he admitted to killing Daniel Pearl, but this was made after he spent all those time in the black sites that and after the torture. So I think they will say again that's still tainted by the.
There's been this huge debate, of course, about whether this should be in a military or a civilian/federal court. How different are the procedures in this proceeding than they would be in a civilian trial?
I think they're very different. I mean, I covered at least part of the embassy bombings in 2001 of the guys that were charged with blowing up 2 American embassies in Africa, and it was a much more transparent system. You had family members of the victims in court with them so they could stare them down. You had witnesses being brought in, tons of evidence, being read, a lot of cross-examination, and it remains to be seen if that's going to happen here. But I think that the difference is that this proceedings is being done on a military base in the middle of nowhere, so people can't even get there.
And the jury, of course, is going to be military officers.
Right. This is much closer to the Universal Code of Military Justice, even more so than the Bush military commissions were. And one of the interesting things, though, is that while there are issues with transparency in it, there are other ways in which, for instance, Saturday, one of the reasons it was so contentious was the questioning of the judge. The voir dire proceedings are in some ways, they're more empowered in the military system than they are in the civilian.
So how long will it be before they actually get to the substance of these charges?
Well, I think starting next month, they're going to start looking at the motions. And the lawyers told me that they're going to file literally hundreds of motions from their access to discovery, from their ability to talk to their clients in confidence, from the resources they've been provided. You have to remember, the U.S. government has spent 10 years now investigating 9/11. And there's a presumption in a case like this that the defense is supposed to have at least some parity in terms of defending their clients. And, so there's a lot of issues that have to be adjudicated.
Some years to go. Well, Arun, Rath, and Josh Meyer, thank you both.
You're welcome.
Thank you.